Good afternoon, it's 1:30. We have a quorum. I will call the meeting to order. Welcome to the City of Oklahoma City Board of Adjustments meeting for November 7th, 2024. The agenda documents and minutes can be found at okc.primegov.com/public/portal. For anyone wishing to be heard today, please fill out a white sheet found at the desk outside the doors and get it to a member of staff. Ms. Lakin will call the case number. The applicant or their representative will be recognized to come to the podium, give a brief description of the case. I will then recognize any supporters or protestants who signed up to speak. They will be given 3 minutes each to express their views. For anyone who is at the podium, please start with your name and address for the record. Next, item number 2 on the agenda, to receive the minutes from the previous meeting.
Motion to approve the minutes from the October 17, 2024 meeting.
Second.
We have a motion and a second. Once able, please vote. No panel, Marcus. There it is. And the motion is approved. Next item, item 3, continuous requests and withdrawals.
So we have item number 3, case number 15688 is deferred till January 9th, 2025.
We have a motion.
Motion to defer case number 15688 to the January 9th, 2025 meeting.
Second.
We have a motion and a second. Please vote. Motion is approved. Next.
The consent docket, there's nothing on the docket.
Right. So next is items requiring a separate vote.
So item number 1, case number 15744, and is appealed by Brendan Westbury of the decision of the Historic Preservation Commission regarding the condition of approval for case number HPCA 240007 in the HP Historic Preservation District located at 3233 North Harvey Parkway.
Hello, hello. Can you guys hear me? Mm-hmm. Okay. So I'm here to appeal the HP decision from August 7th. Essentially, they said that the pergola should not be attached to the house and there should not be a covering on it. So the disallowance of solid roofs on freestanding pergolas on historic standard grounds, I believe, is illogical, considering that the same historic preservation guidelines allow solar panels to be built onto the property. When we were discussing the material used to cover, that was the problem. And there's a number of other things that are allowed that fit that description, first being solar panels. In fact, the preservation guidelines even go so far as to recommend solar panels or solar power on page 22 of the standards and guidelines. If solar panels are deemed to be historically appropriate, then it stands to reason the similar looking panel structure should be treated the same. It's a counterintuitive argument to me. In addition, the commission administratively approved the construction of a fire pit, built-in grill, pizza oven, and electric smoker. So it's beyond me how these items can be deemed appropriate, but a roof that would be used to protect said equipment and prevent it from falling into potential neglect and disrepair wouldn't be. Further, the guidelines allow for multi-story garages and accessory buildings to be constructed in full view from the right-of-way, which to many would be considered far more detrimental to the appearance and historic nature of the neighborhood. So to me, it's pretty clear that the guidelines do not seem to be congruent from one section to the next. as a roof on a pergola is a significantly smaller construction, yet it is not allowed. The guidelines also allow for the construction of new roof features, such as skylights, to be installed, as long as they are in the back of the house and not visible. This pergola would be in the back of the house and not visible. So I fail to see the difference between a skylight being constructed on a roof and a similar style roof material being built on a pergola. It's another example of the guidelines being incongruent from one section to the next. The current decision from the commission essentially basically prevents homeowners who do not already have a covered patio from ever being able to build one without constructing a larger, significantly more elaborate, and less historically appropriate addition to the home. I've spoken at length about this project with my neighbors, and they have all been in agreement that they believe the plan is appropriate, stylistically pleasing, and would be a fantastic addition to the property and the neighborhood. I've provided renderings of the plan. Further, as an aside, my wife and I have put so much time and effort into the upkeep of our property. When we bought it, it was in disrepair. We're halfway there. Our patio currently is in disrepair. And the lack of being able to move forward without knowing what we're able to do, or not being able to do what we believe we should be able to do, is actively preventing us from making our house look better. We have put years and years into our backyard that was in disrepair. We have put even more years into the front yard and the upkeep of this house. We're trying to make this neighborhood better. And I think all of my neighbors, and I've actually had people on the street walking by say thank you for what you're doing. So I just want to point out that I'm not trying to harm the neighborhood at all. I'm trying to make it better. This is a place that I want my family to continue growing, and it's a place that I want to be here for the long run. An additional facet of the application was to have the pergola attached to the house instead of being freestanding. Upon review of the docket for the August Historic Preservation meeting, I noticed that my communications to the commission regarding the method of attachment was not included and presumably never reviewed, despite being sent on June 4th. There were also several clerical errors within the docket that the commission made, such as misrepresenting the square footage of the pergola and repeatedly calling the pergola's roof flat, when all documentation and applications had the correct square footage of the pergola and stated there was a 6-inch drop from the east side to the west side of the roof to ensure proper drainage. Really makes you wonder how often things like that have happened and have gone unnoticed. I also requested assistance from the commission in being provided standards for how any new construction should be attached to the home to prevent moisture buildup or damage. Not only did I not receive any such documentation, but the commission actually stated to me it does not even have any documentation to provide. And I have it on attachment 3, I've attached that communication. I believe it's just absurd that homeowners are held to standards of construction that the commission cannot or is unwilling to define, and makes one question how they come to certain conclusions when there is no documentation for anybody. It should also be noted that there are 2 pictures of pergolas in the standards and guidelines that are used as reference material that are clearly shown in these standards and guidelines to be attached to the dwelling on pages 54 and 91, which seems to me would lead to general confusion and a lack of clarity for homeowners. Thank you.
Any questions from the board for the applicant right now? Maybe we should hear from Ms. Friddle from the Historic Commission, well, staff.
Hi, so I'm happy to answer any questions you might have. What I do want to make clear is that this is an application that was approved by the commission with conditions to which the applicant agreed. So typically, if an applicant then decides, I'm not actually comfortable with what got approved, I'm not comfortable with those conditions that I agreed to, they would come back and submit an application to revise their CA, and that would go before the commission. With this application, unfortunately, the commission has a limitation on how many times they can hear a case. It can only come before them 3 times, and then they have to either approve or deny. This was heard twice prior to the hearing where it was approved, but the applicant was not present, so there wasn't really any discussion about the project. There was no opportunity for the commission to ask questions about the method of attachment. We did miss that email, and that did not get incorporated into the packet. And if we had known prior to the meeting, we would have distributed that to the commission, but we just didn't see that come across. I think had we had one more meeting, it's something that would have been continued for further discussion and probably coming to a resolution that the applicant was happy with. But I'm concerned about an appeal being used to overturn something that was agreed upon between the commission and the applicant by the applicant from a procedural standpoint. And I think we could continue to work toward a solution for covering the back patio that can be approved by HP.
And so at the commission meeting, it was approved with some contingencies upon
Yep,
the applicant to provide a plan.
right, to make some
And-
revisions
and
to
then
what had
to
initially been
change-
proposed and to
change-
provide those revisions to staff.
Okay.
That was not my interpretation of it, but I understand if maybe I misinterpreted. Being that it was the last meeting, I wasn't able to be at the first two. I was told to work with the commission to detach the pergola from the house and can't have a covering. That was the decision that I was under the understanding that it was to be made. The commission said we do not allow coverings on pergolas. So I don't know where I was supposed to go from there regarding that information, like without coming to an appeal.
Well, and you had agreed to said,
I agreed to taking a look at those conditions, and if I was okay with it, we could move forward, but I'm not okay with that.
I mean, the idea of coming here to file an appeal against a positive result. Maybe I'm,
This board is to review appeals from an adverse decision, a decision that the applicant is not comfortable with. So if there is information that perhaps the two of them could speak, perhaps a continuance of this item might be appropriate so that they can visit and see whether they actually are as far apart as the applicant might imagine that they are. That would give more time and an opportunity to discuss it.
or if it was remanded back to the commission, since the meetings had turned out, you can't have another meeting, but,
Right.
and we remand it back, and does that start over?
Yes, so I think we hear it as a
New
kind of
case?
a fresh start for that case. So
But
they
the
would
applicant
have,
doesn't
they would have
have to reapply?
continuances again, they could go through the process again. Yeah,
So either one of those would be fine because it would give an opportunity for conversation.
More communication.
Yes.
I was thinking about the remand, but that was going to be my question as to whether or not, because it sounds to me like there's an additional hearing that's going to be required. So if we remand, we're going to give them the opportunity, right?
We give the applicant the
Yeah.
additional opportunity.
Because too, there will be a new staff report that will contain all of the history of the application, and the commission will be allowed to review that. And of course, Katie will be there to explain what happened here, and the report will include all historic parts that have occurred so far.
Okay.
There is someone signed up to speak. William White.
Good afternoon. William White, 3200 North Harvey Parkway. I'm a neighbor directly across the street. I came this morning to support the applicant. I think the idea of a covered pergola is reasonable, especially with the application of the materials. My background is architecture and engineer. I have my own firm, and so the transparent application of the roofing material seems very reasonable as shown in the renderings. Also, the attachment to the house as a structural element, obviously the pergola can be independent, but attachment will allow for lateral support and seems very reasonable. I think Brandon is correct that the industrial view of solar panels versus a transparent covering seems more reasonable and acceptable. And as I may be the only neighbor that could see a portion of it, I'm in support of the application as it is. I think conditions can be viewed as, a conditional response can be viewed as a negative instead of a positive. I think I understood how Brandon interpreted it, that the conditional aspect of staff and the committee was a obstruction, and so I understand his appeal. So in end, I appreciate his investment into our neighborhood and his personal residence. I think as a resident who has an outdoor grill, in the recent storms now looks like a popcorn grill with the number of health beats that I've had on it, I understand the idea of protecting your investment, especially in an outdoor situation. So in the end, I'd like to support the application as it stands right now, and hopefully you'll approve it today.
Thanks. Questions or comments?
Yeah, I have a question for Katie. Is it your understanding that at the meeting that the agreement that the Historic Preservation Commission had with the applicant was one where they negotiated these terms, or was it one where they simply stated, we're only going to approve it on these conditions?
So we were at the point where they needed to either approve it or deny it, and said, we're not comfortable approving it like this, we're not comfortable approving it like that, would you agree to these conditions? And the applicant said yes. So they approved it. And I just listened to the recording on PrimeGov before I came over here, so that is the discussion. Here are the conditions we're proposing. Do you agree to that? The applicant said yes. Had the applicant said no, discussion would have continued, and we would have either ultimately denied the application, in which case I think it would be appropriate to appeal the denial, or we would have worked our way around to some other resolution to the issues the commission had. I think in large part we ran out of time because we hadn't had previous meetings to work through the things that were raised as concerns by the commission and to get that additional information from the applicant.
Well, I'm torn because like you, I don't think that an appeal is an appropriate process just to make a modification, so to speak. But at the same time, the flip side of that coin is one where presumably the Historic Preservation Commission would still not grant his request, in which case he would still end up back here. So just from an efficiency standpoint, I don't want to send him back if he's just going to end up right back here. So in your, and I know you can't speak for them, but in your opinion, is it likely that they come to an agreement?
I think there are lots of paths to an approval of an accessory structure of some sort covering the patio. I think we, even with the documentation we got of the method of attachment, we would want more of an actual drawn, dimensioned architectural detail of how you're tying that into the house, if that's the method, or we would want to see that it's detached. We approve accessory structure types of things that are open with a solid roof on a regular basis. The definition of a pergola specifically calls out that it's an open roofed structure. So we would need to kind of recategorize how we're thinking about this structure, but I think there's absolutely a path to getting a covered patio of some sort or another at the property. Perhaps not exactly as it was initially proposed, but it's something that we could get approved.
So can I just speak to that? Like, at the meeting, I also agreed that if we were going to deem it as an accessory structure and not a pergola, I agreed that I would hold this project to higher standards to connect to the wall. And I never received anything about how to do that. Like that's really the issue of that portion of the project, is like they.
I don't think it's the Historical Commission's place to give you the design structure. That's just not what they normally do, right?
But if I.
It's up to you to have the engineer drawing and them approve it.
But it's not, I should have printed this off for you or added it to I did have my contractor explain and draw up exactly how it's going to happen, and that I presented it that day. I know they didn't have the opportunity to review it because they missed it, but when an applicant is told that they don't have any documentation but are requiring you to prove something, like, shouldn't there be something behind that that way they can say yes or no? Like, that seems to make sense to me, right? Like, that is approved, that is not.
So I think every house is different, the way the houses are constructed, what the building materials are, the method of construction for what you're building. we don't have an array of kind of sample spec sheets to provide to applicants. I'm sure we could find something from previously approved cases that would be a reference point. But yes, typically it's the applicant's responsibility to be working with a professional who knows how to do the work properly and knows how to document the work that's being done and to submit that.
So there were supposed to be 3 hearings. So what happened to the first 2?
So the first 2, it was just continued because no one was there.
I wasn't able to make it. I had prior commitments.
Okay. So I'm not willing to grant you an appeal on when you weren't present there for the first 2. I'm willing to remand it, and then you guys can continue the discussion outside of this forum. But I'm not willing to grant this this appeal on that alone.
Good. A motion?
Motion to remand case number 15744 to the HP Commission.
Second.
So we have a motion and a second to remand case number 15744 back to the Historical Commission. Vote. And the motion passes.
Item number 2, case number 15736 is an appeal by Lamar Central Outdoor LLC and Byron's Liquor Warehouse PSG Reynolds LLC of the decision of an administrative official regarding the issuance of a sign permit at 2306 North Broadway Avenue.
Hello, William Hickman here on behalf of the applicants. Just as an initial matter, I wanted to at least go ahead and make the request for a continuance. There's only 3 of y'all present. You 3 have heard this appeal before, and in a matter of efficiency for your time and the time and expense of my client, I request a continuance to the next regularly scheduled meeting, since you've heard these arguments basically before.
David Box, 522 Colcord Drive. We would object. Understand that it's the same, or not all the same, but all 3 of you were here last time, and it was Noble voting to deny Lamar's request, and then you 2 voting to sustain his request. We left that hearing believing that there were really 2 main issues, each raised by you guys. We filed supplemental pleadings that I trust you've read, specifically relating to the right-of-way question that seemed to be a question of concern, and whether or not that railroad was right-of-way or because it was owned in fee, it wasn't. Hired a title company, went through all that effort, submitted supplemental pleadings, proving that it is right-of-way. Our hope is that the 2 concerns that were put forward by you 2 through supplemental pleadings and argument from the podium, that we'll be able to solve your problems that you potentially had with our side of the case and obtain a 3-0 vote in our favor. And in terms of the efficiency, our portion of the presentation I would expect to be limited and really just addressing what we left believing were outstanding issues.
I'd like to hear it.
I'll make a motion to deny the continuance request.
Second.
Motion. We have a motion and a second to deny the continuation request. And that motion passes. So we'll hear the case.
Okay. Okay. So I have some slides in here that you have seen before, and I'll just try to move through, or some of the exhibits, I'll move through these quickly. We talked last time about the purpose. One of the purposes of this article regarding the sign code relates to the implementation of the city's comprehensive plan, promoting community aesthetics, things of that sort. If you can go to the next page, next slide. This is the excerpt from the Plan OKC, policy number E14, which identifies that one of the policies and purposes, if you will, under Plan OKC is to restrict new billboards and to eliminate or reduce the number of billboards. If you look at the next section, it deals with the purpose and findings of the city's sign ordinance. One of those findings relates to the types and dimensions and setbacks and designs permitted for signs and billboards. Talks about the uncontrolled use of signs, including billboards, and the location may harm traffic safety and public well-being, which I believe you heard comments from my clients before about that regarding public safety with regard to Byron's Warehouse Liquors. And standards set out in this article were developed by public process and therefore have the support of the public, just like the city's comprehensive plan. This section deals with the applicability and provides that where there is any conflict between these regulations in the sign code and regulations in the design districts, such as the historic preservation districts, those more specific districts, the zoning districts, the historic districts, I'm sorry, that those regulations are to prevail. And then we have the section in the sign code that deals with the general rules of interpretation, which is part of what your job is here today, acting in a quasi-judicial capacity, is ensure that the minimum requirements adopted in this code to protect the public health, safety, and welfare, and that when there is a requirement of this article that varies from another provision of this title or any other duly adopted city ordinance or any duly promulgated rule or regulation of the city, the more restrictive or the more imposing, the higher standard should be the one that applies. So I want to highlight these three things again for you, because what this talks about is that the city's comprehensive plan says to restrict billboards. This ordinance itself says applicability, that the more restrictive standard should apply. And in your interpretation, you're supposed to apply the higher standard. So if there is a potential for a conflict, the one that is more restrictive is the one that you are to apply. So if it's not clear what the interpretation should be, the purpose of this background information I'm giving to you today is this general rules of interpretation, the city's long-term comprehensive plan that went through hours and hours and hundreds of people's participation, say to restrict billboards. And so if there is a question of doubt, you should interpret these ordinances in a manner that are restrictive to billboards, not that are granting of billboards. The next slide. This next section deals with off-premise signs and billboards from the city sign ordinance. And this is the key provision that we talked about last time in section H. In particular, subsection 3 says that no billboard should be constructed, erected, placed, or replaced closer than 300 feet to the nearest HL or HP zoned property. Again, you might remember we discussed that this sentence says the word no billboard. If you look at the next page, it defines a billboard as a sign or a sign structure upon which advertising may be posted, painted, or affixed, and which is primarily designed for the rental or lease of the sign space for advertising, not related to the use of the property upon which the sign is located. So a billboard is a sign or a sign structure. We talked also about what are the definitions of those two terms. And if you look at the next page, sign structure is any combination of materials to form a construction for the purpose of attaching, fixing, or otherwise supporting a sign, whether installed on, above, or below the surface of the land. Then a structure is anything built or constructed, whether or not permanently attached to the ground. So we have clear definitions here that the spacing is from a billboard, and the billboard is a sign structure, and a sign structure is anything supporting the sign, part of the construction materials of the sign, whether they are installed on, above, or below the surface of the land. Why am I highlighting this for you? You might remember, if you look at the next section, the objector, the protester, native, they assert that the way the measurement should be done is based off of this section 59.16111, which is a measurement, as it says very clearly in the first sentence, the measurement for the spacing requirements from the center of the sign support structure and following the curvature of the geometry of the right-of-way. But as it clearly says in section G, the paragraph identifying what this is about says it's spacing between billboards. It doesn't say spacing between HP properties. It's between billboards. In the interpretation of the ordinance, words matter. And the words here are clearly saying that if you're measuring spacing between billboards, then it's center of the sign. And you might remember I gave you some examples, that one of which is that we call this a flag structure. which is where the pole is in one place and then the head, the part of the sign structure that is above ground can be projected 50, 100 feet away from where the sign pole is, and then would be even more closer to the area where it's supposed to be spaced away from, which shows the potential absurdity of an interpretation that says the measurement should be from the sign structure, from the center of the pole, and not from the actual sign structure, when in fact, the structure could be pushed through the technology and the use of devices like this within feet of an area where it's supposed to be away from, which is why the proper interpretation, as the words say in the ordinance, is that the distance should be measured from the sign structure, whether below, on, or above the ground as shown in this picture. The next section I want to talk to you, or the next thing I want to show you, is why is this important? And this is the measurement that the survey that we showed to you last time, which I know is a little hard to see here, but you can see the difference between the measurement. If you measure from the farthest point from the sign structure, it clearly protrudes into the property next to the fire station. If you measure it from the center of the pole, as they have requested, it goes right up to the curb. But this is not the only argument with regard to the spacing issue. I want to point out some additional things that we've identified that support our interpretation and the application of how the measurement should be done. So if you look at the next section, again, this is the portion that talks about, in section 3, the measurement is 300 feet to the nearest HL or HP zone property. And I believe a couple of the commissioners had questions last time about the zone property piece, and I want to get to that in just one second. If we can go to the next exhibit, which on this exhibit, it shows the references to, in the need exact sign location on the site plan, it says billboard cannot be closer than 300 feet from nearest HP or HL zoned property. And so it refers to the billboard here, just like it does in the ordinance. It doesn't say the center of the pole. And then underneath the comment section, it says, although this site is not located in a design district, there is an ordinance requirement concerning minimum separation between HP zone property and billboards. It references where it's located at, and it says the applicant needs to provide a detailed site plan showing the proposed location. Now, what's interesting here is after this feedback through this process, the sign originally that was proposed was a center mount, which means it was in the center of the location of the sign face above ground. But when they were given this feedback and realized that they didn't have the spacing, they moved the pole to the corner and then created what's the flag unit that you see now, which I also showed you in that picture, to try to create the spacing from the 300 feet. And you can go back and look at the prior applications. You can see that they changed the way that they were going to do their sign to try to make this argument that it should be from the pole by moving the pole to the corner and creating the flag unit, which only further substantiates my client's concerns of how the system can be gamed if you measure it from the center of the pole, because people can use these flag units to avoid the spacing issue that's intended to protect the various things that are identified in here, including residential structures and historic preservation areas. And also important on this page is to show next to where it says the word note, it says zoning lines go to the center of the street right of way, and that's referenced by Laura Griggs. And so if we look at the next page, what I'm showing you here is a new survey that we have done that shows you a couple of different things. And I'm going to walk through the backup documentation in a second, but I want to point this out to you. The first item is you see a turquoise curved line right above the word HP district. That is the boundary line for the historic district on the city's own site, website. Right below that is a black dashed line. That line represents the platted and zoned property, the Winans addition, prior to any road work being done, which was also deeded by the Winans family to the city of Oklahoma City. And I'm going to show you that backup documentation in just a second. And then the big bold green line, I can hardly read this from my, is the boundary as defined by Heritage Hills East Urban Conservation District as per ordinance 17225. That black dash line is the HP Historical Preservation District property platted as Winans Park bounded by the Broadway Avenue as per ordinance 21-204. So whether we are talking about ordinance 21-204, which is the bounded area of the platted property, or we're talking about the limits of the HP district as per the City of Oklahoma City's own zoning map on their website, or we're talking about the boundary of the Heritage Hills East Urban Conservation District as per ordinance 17225, you can see that even 300 feet from the center of the pole, which we don't think is correct, protrudes into all three of those areas. Now, if you look at the next exhibit, and the full documentation that we submitted to you, I just tried to create this streamlined version to move through this more quickly, is the warranty deed that I mentioned from the Winans family to the City of Oklahoma City. The next page is the Winans Third Edition, the platting of Winans Third Edition, showing the lots, streets, and blocks, and I've highlighted the park in the center and the properties surrounding it, including those closest to the area near the Byron's Liquor Warehouse. The next slide, or next page, is a portion of ordinance 21-204, and it shows you at the bottom, property, this is your city ordinance, says, property platted as Winans Park bounded by Broadway Avenue, Northwest 20th Street and Northwest 22nd Street. And there's the rest of the legal description there in between, but it refers to it as property platted. And I believe the conversation before was this property, is there property that was platted? And this was property that was platted. And as I showed you in the prior slide, the prior two sections, it was deeded by warranty deed from the Winans family to the City of Oklahoma City. It was platted and zoned as the Historic Preservation District by ordinance number 17. I'm sorry, by ordinance number 21204, which is on that map I had shown to you previously. And just to be clear, that property is still owned by the city by deed. Still, the plat still exists and is in the court records, the county records. And so if the city, for some reason, wanted to go out there and take out the road and put land back in and recreate the dirt there that you'd see this property, they could do that. So it is still platted property with these historic plat property designation granted to it or overlaid or provided on it by ordinance number 21204, which is on the map that I showed you previously. If you look at the next section, this is ordinance number 17225, which I also have on the map, and it provides, if you go to the next page, the district designation, which I've highlighted the eastern portion, which refers to the center line of the northbound lane of Broadway surrounding the park. And if you look at the next page, this is a visual depiction of that boundary, which it goes around to the center lane of the road adjacent to the east of Winans Park. And it's also depicted on the survey that I provided to you. So let's go back to the survey. And I have some larger blow-ups, if it would be helpful to anybody. And if you're like me, I also brought a magnifying glass with the light. So if anybody needs visual assistance or a larger map, I'm happy to provide that to you. If that would be of assistance, just let me know. But again, if you look at this survey, and even going from the center of the pole, which we do not think is correct, you can see that it first crosses over the green dark line, which is the boundary per the city's ordinance 17225 for the Heritage Hills East Urban Conservation District. If you continue to go, you see it pretty much simultaneously crosses over the blue line, which is the limits of the HP district as per the City of Oklahoma City zoning map, as well as crossing over the black hatched dashed line, which is the boundary for the Historic Preservation District, which also overlies with the boundaries of the Winans Park as platted, and that's per ordinance 21204, which was adopted on January 28, 1999, which also tracks to the warranty deed conveyed by the Winans family to the City of Oklahoma City. So we believe, based on this new information, there should be a 3-0 vote today to grant the appeal, to be honest with you. Because this clearly shows that there is platted property that is within 300 feet of either the pole or the structure. And it doesn't matter what ordinance we use, whether it's the one on the city's map or the one on the city's drawing on its own zoning map, or the two ordinances I referred to you regarding historic preservation, this sign is too close and it does not meet the requirements of the spacing that's set forth in the sign ordinance. I do want to make one other mention of another item, if we go to the next page. What you heard last time and what I anticipate you'll hear again from Native, the protester, is that they refer to this section 59-5250, and in particular section C, and they say that for purposes of applying the development regulations of an individual zoning district, all such requirements shall be calculated from the appropriate right-of-way delineating a street or alley, which they had said before would be the curb. At this point, that argument doesn't matter if you look at what we have presented to you regarding the ordinances and the spacing from those ordinances. But even if you thought that that wasn't enough, if you read this section, it's delineating the district maps. We know what the district boundaries are. I've showed them to you, 2 ordinances and the city zoning code that's on their website. But even going beyond that, this section applies to individual zoning districts. This is an I-2 zoned property. We're talking about a use here in the form of billboards. That's not a zoning district. So our argument and our belief is that this section doesn't even apply. But say even if it did, and you looked at the underlying zoning district of I-2, there's nothing in the I-2 district that talks about spacing from HP. But if you had to go one step further and you were going to call it for the curb, then you should measure from the curb of the property that we're talking about here to the curb of the park property. And then that also is not 300 feet, because that would not be from the center of the pole, because the center of the pole does not set at the edge of the property. So frankly, we don't believe that this section of the ordinance has any application, but even if it could be construed in some hard attempt to make it apply, it still does not create the spacing that is required and necessary to avoid being within 300 feet. The next thing I want to just talk to you about briefly is, again, relating to the idea that billboards are only permitted on property that abuts streets. This property does not abut any street. If you look at the next slide, you can see on Native's own aerial, on the right-hand side, you see where it refers to Lot 2. It's bounded on all sides by property. It does not have any frontage along any street. If you look at the next section of 16111, the location that's required shall comply with all established building lines and setbacks. We talked about this also a little bit. Again, this property does not meet the setback requirements at 25 feet from a property line. And if you set it back 25 feet, it would be also not able to meet any kind of spacing requirements, although it does not meet them already. If you look at the next page, this shows you also on this schematic that it's a Native's document. To the right of that Lot 2 is the area that's identified as the railroad right-of-way. Not right-of-way, the railroad property. If you look at the next page, we submitted to you a deed to the Atchison, Topeka, and Santa Fe Railroad, indicating that it was deeded to them and deeded as the fee ownership as to this particular strip of property. And that's further evidenced, if you look at the next page, on the county's map showing the owner is the railroad, Atchison, Topeka. And if you look at the next page after that, this is going back to that same section of the signed ordinance, talking about where there is no building setback established by ordinance or subdivision plat. Billboard should be set back from any lot line abutting a street at least 25 feet. So we don't have a street here, and we have a private property owner next door. So there's not any type of 25 feet setback, because if the railroad went out there and chose to build something, you would have a billboard sitting right on the edge of the property, which, if you look at the next slide, on the next page, indicates that the city has told Lamar in the past that that's not allowed. You have to have a 25-foot setback from the closest point of the sign face. This is from the adjacent property. And so we're just asking that for a consistent interpretation of the city's ordinances. And I have one or two more slides here, and I think I have another one of these billboards that show how it can be protruded with a flag unit and how the setback requirements as well as the spacing requirements are circumvented if you don't interpret the way that we are urging because of the use of a billboard sign like this one. Then the last thing I want to show you again is our survey, again showing that no matter where you measure from, the center of the pole or the edge of the sign structure itself, which is what the ordinance says, it protrudes into all three of the designations identified by the city as HP property, whether it's the two ordinances or the city's own zoning map. And for those reasons, we'd ask that you grant our appeal and reverse the decision of the administrative official by revoking the permit. Thank you very much.
Thanks. Any questions from the board for the applicant?
Good afternoon, David Box, 522 Colcord Drive. Mr. Hickman referred to my team as the protesters. I want to make sure it's clear that we aren't the party here protesting. That would be Lamar. My client is the party that lawfully received a permit to install the sign by the city of Oklahoma City. So I want to start by reading an email that we received from Scott Wise, who's here with us today. Scott Wise is in plan review. This is June 24th, 2024. And he states to Mr. Hahn, who is a lawyer in my office, the Development Center, the Planning Department, and legal are in agreement that the billboard spacing is measured to the center line of the pole and that the distance is measured from the edge of the property, not the zoning district. Therefore, the distance is measured from the property line, not the center line of the street. It so far appears that you meet both of these requirements, and as such, you will not need a variance from either. Mr. Hickman and Lamar put a significant amount of reliance on the comprehensive plan, as if that had some sort of legal impact on a property owner's ability to pull a permit and develop their property. It doesn't. Plan OKC is a policy document that is used in rezoning applications, not permit review. The reason being is how Plan OKC is adopted. Ordinance are adopted by City Council. They have the effect of law. Plan OKC, unlike an ordinance, is adopted by resolution without notice to property owners. You can see why that would create a problem. If you could really impact property rights via comp plan, you could do so without the property owner ever knowing that this document has now been put on their property that would somehow limit lawfully approved uses. Here, the subject property is zoned I-2. There's no dispute. I-2 absolutely allows non-accessory signs. At the last hearing, well, for purposes of the record, let me incorporate all the previous arguments we made at the October, I believe it was 3rd Board of Adjustment hearing. So we had a lot of discussion about how the fee ownership of the railroad impacted setbacks or whether or not we abutted a highway for purposes of being allowed to develop a billboard. Mr. Hickman walked through that analysis again. Post that hearing, we hired a title company to go and dig up and see what we could find as to what this railway was at the time of acquisition. What we found was, and I trust that everyone has read our October 11th memo that was submitted after the last hearing. And what it says is, beginning in 1884, when an act of Congress approved a July 4, 1884, 23 Statutes at Large 73, entitled, An Act to Grant the Right-of-Way through the Indian Territory to the Southern Kansas Railway Company. Since 1884, when the railway was built, Congress granted them that land as right-of-way. If you look at the documents contained as exhibits to this October, the October 11th memo submitted, hopefully you've read it, it says, again, those words, that by act of Congress approved July 4, 1884, 23 Statutes at Large 73, an act to grant the right-of-way through the Indian Territory to the Southern Kansas Railway Company. Before rail lines were ever put down, it was and remains today right-of-way. Doesn't matter if it's held in easement or fee, it is right-of-way. It was right-of-way before Oklahoma was a state. Always has been right-of-way. That kills their argument that we don't abut a highway. Further, it doesn't matter. Even if you didn't agree that in 1884 it was granted as right-of-way, the sign code allows signs based upon the street typology of abutting streets. This property abuts Broadway. Broadway is a major arterial. A major arterial with I-2 zoning explicitly allows a billboard. So we actually get the billboard both ways. Whether we abut 235 because it's right-of-way and not property, or because Broadway Avenue is a major arterial and we are zoned I-2. There's two paths on that to get to us being allowed a billboard. So then there was this discussion about the HP property and where you measure it from. And we, like Lamar, think it's important that consistency does apply. Again, it's very ironic that Mr. Hickman continues to show this very egregious example of a flag billboard, because that is a Lamar billboard that they've simply scrubbed digitally, the Lamar emblem that's held on the apron. If you want to look at what we actually propose and what our permit is, it's page 2 of Exhibit 8, and you can see that it is not the egregious flag that Lamar has implemented in our market. So what the municipal code says on this very issue as to how do we determine distance here, the distance from the center of the pole to an HP zone property, Chapter 59, Section 5250.4 sub C says, for purposes of applying the development regulations of an individual zoning district, all such requirements shall be calculated from the appropriate right-of-way line delineating a street or alley. Well, what could that be other than the curb? The right-of-way line delineating a street is absolutely a curb. That is how it has always been interpreted by the city of Oklahoma City. And when you take that, and this is the survey that we provided to the city, we are outside of that 300 foot, because here is 300 foot from the center of the pole, and as you can see, it doesn't touch the curb. It falls short of the curb. This is how the city measures. Mr. Hickman closes his argument by saying, well, we don't think it applies. Well, of course they don't think it applies. Why would they think that the way that the city has always measured distances applies? Because it doesn't fit their argument of this case. But let me read it again. For purposes of applying the development regulations of an individual zoning district. So what we're talking about are, of course, the development regulations of the I-2 zoning district. That is what we're talking about as it relates to separation from HP, HL, et cetera. So again, for purposes of applying the development regs of an individual zoning district, that's what you guys are tasked with doing here today, all such requirements shall be calculated from the appropriate right-of-way line delineating a street or alley. Here we don't have a street, so where is the appropriate right-of-way line delineating a street? What else could it be but a curb? I think everyone would agree, this is street, this is street, this is street. We hit a curb, it's no longer a street. It's grass, it's the private property, it's a yard, it's not a street. What delineates a street? What do I tell my kids to stay away from? The street? How do they know where that is? It's where the curb is. That is what delineates a street. That is what Chapter 59, 5240.4 sub C says we have to do when we're determining where we measure these things. Delineating the street. We are more than 300 feet away from the delineation of the street. Plain and simple. As staff said in the email that I read, the distance is not measured from the property line or the center line of the street. And the reason is, it's not an opinion or just the way they do it. It's because of the provision I just read you. Staff is not guided by keeping away competition, We're trying to ensure market share. Staff is guided by the ordinance. Staff is guided by history. Staff is guided by how things need to be interpreted evenly and fairly, regardless of who the applicant is for that permit. That's why staff looked at the curb and said that, of course, is where we delineate a street. Therefore, that is why, for purposes of applying development regs of the individual zoning district, 300 feet is what we're dealing with. This particular permit application meets it. Last time we were here, Lamar's representative stood at the podium and told you that he had been invited here by the city to be a part of this conversation. Make no mistake, that's simply not true. I think it's obvious to everyone in the room why Lamar's here. They're not here to engage in a conversation. Lamar is here for one purpose and one purpose alone: to stop competition in the city on a location that they were previously denied on by ODOT, again, not the city. Why they didn't choose to appeal it up and get a ruling based upon the plain language of the statute, I don't know. But they can then come back now and complain that they're just here to be a part of the conversation. They're not. They're simply here to try to stop anyone else in this market from being able to use their property in a manner consistent with the zoning ordinances that exist and that they own property allowing. So for those reasons, we would ask that you follow the guidance of, again, as the June 24 email from Scott Wise, the guidance of Oklahoma City's Development Center, Oklahoma City's Planning Department, and Oklahoma City's Legal Division. All of those departments, in reviewing the ordinance, came to the conclusion, based upon the facts and the way that the city does these things, that all ordinance requirements to build a non-accessory sign on this site were met. For those reasons, and all of the reasons previously argued, we ask that you deny the appeal of Lamar. Happy to answer any questions.
Any questions from the board? And no one has signed up to speak. Mr. Hickman, you can answer.
Yeah, I just got a few things to say briefly. First, which is I don't know why Mr. Box feels compelled to always try to attack my client and act like they're trying to hold back competition when the city has plainly said that they have they don't enforce their sign code unless somebody comes forward and complains. So if we don't come forward and request enforcement, it's not done. And so if the city wanted to proactively enforce its ordinances, then my client would be happy not to have to pay me to be up here making arguments and trying to ensure things are properly enforced. Number two, we're here because we disagree with staff. I mean, reading to you things from staff's email, I mean, that's the whole point of you guys being here, to review the decisions of the staff. So, you do it de novo, which means you don't give deference to what the staff said. So, again, with all due respect, that doesn't matter what staff had to say. But I would point out that originally staff's legal office disagreed with Mr. Box and said, if you can go to the section of the ordinance that Mr. Box is referring to about defining the boundary. Yes, that one. Section 5250. Susan Randall with the city's legal office in an open record email initially said that that was the section that applied. And then all of a sudden there was darkness, quiet, probably some meetings and conversations. I don't know. And then all of a sudden, okay, we'll agree with you guys. It's Part C that applies. So I just want to be transparent that there is documentation out there from the city staff, legal division, that initially said they thought it was Part B of this section. We don't think any of this section applies, to be clear, because this section deals with zoning district maps. And we have two ordinances and the city's own zoning map outlined on the survey that we provided to you. So this is an attempt to bring in an ordinance that doesn't even apply. Because why does it not apply? Because we're not talking about a zoning district. Mr. Box said this is I-2, and it's I-2 zoning that has a setback requirement from HP. That's not accurate. The section of the code that we're looking at is the sign code. It's not the I-2 zoning district code. And so if it's not the I-2 zoning district code, then how does this apply? And again, if it does, then it should be from the curb to the curb, from the I-2 curb, because they want to mix and match. We want to do it from the pole when it's in the sign ordinance that says that. We want to do it from the curb when it's the I-2 zoning district. Well, if gotta use the zoning district, then it should be from the zoning district to the zoning district, from the curb to the curb. If you look at our survey and you go curb to curb, there's no way there's 300 feet, there's even less space. So again, let's be consistent. Are we going to use the sign code, which is actually the code that applies? They're applying for a sign permit, which means it's not a zoning district, which would mean this section, again, is irrelevant. It might apply in other scenarios when we're talking about someone asking for a permit for a building that's on I-2 zoned property. That's what this is intended for, but this is a billboard. It's a different animal. It doesn't apply. I'd also point out that if you look at our warranty deed that I provided to you, and I know I only showed you on the screen the one page. And again, you know, this is only a secondary argument of ours, but it's the deed to the Atchison, Topeka, Santa Fe Railroad. And if you look at the paperwork we submitted to you on page 2 of that, it also actually indicates there's a filing map in 1889 and an affidavit in 1981, that shows, and if you look at the back of the rest of the paperwork, one of the lines says, part of the conveyance is together with all second and other additional tracks and all extensions, branches, side tracks, turnouts, spurs, passing tracks, and all appurtenances thereto, including all right-of-ways, station grounds, and lands, and all interests in land now used or held for railroad purposes. It doesn't just grant a right-of-way. It talks about granting the lands and all interests in the lands. In the actual warranty deed that is in 1899, after the general conveyance that Mr. Box made reference to by the U.S. government. But again, even if you set that aside, Mr. Box then tries to argue that the setback aspect of this, that they have property that bounds Broadway. Well, their own map shows Lot 2, and it does not bound any Broadway. I would challenge them to bring to you any documentation that shows an interest in the property where the billboard's going to be erected that bounds on Broadway. Because I'm familiar with the easement document that they have, and the easement site for their billboard does not touch Broadway. It's Lot 2 on their survey that they have shown to you. And how do I know that? You talk about being a bully and not wanting competition. They've already filed a lawsuit against some of the applicants in this case that they told you last time that they were going to do, trying to shut them up and get them to walk away from standing up for what are their legal rights to speak what they believe. So Lamar's not the bully here trying to stymie competition, filing lawsuits. We're following the proper procedures and not threatening anybody. Mr. Box also made a comment, this is how it's always been interpreted. I don't see how that's accurate either, because to my knowledge, and the city's staff report makes no reference of prior interpretations of this section of the ordinance, because it's new, how the measurement should be done, which is what we urged you last time, why this is important. And if it has been interpreted this way, then staff should put it in their staff report and tell us, because that would save a lot of time and effort. But I've been here for 25 years practicing billboard law, and my client's been around longer as a billboard company, and I couldn't find any evidence of it having been previously interpreted this way or being previously interpreted at all. And to our knowledge, this is a new question of interpretation, which is why there's not anything in the staff report pointing out how the measurement should be done for this specific section of the ordinance about distance from HP property. Words matter. It says the word billboard, 300 feet from HP property. I've shown you the definition of the word billboard. I've shown you where the HP property is platted, was deeded, platted, and exists still to that day and is zoned as shown by the city's own maps as HP. And it is not 300 feet away from the sign pole center, which we don't think is even correct, and it's certainly not from the sign structure itself. So for those reasons, we'd ask you to grant the appeal and to revoke the permit granted by the administrative official. Thank you.
Perhaps we could be done. So I think Mr. Hickman perhaps is confused because he keeps saying this is the sign code. The sign code is part of the zoning ordinance. The sign code is now housed within Chapter 59. Chapter 59 is also where I-2 rules are. So the zoning ordinance absolutely applies, which contains both the sign code and the I-2 regulations. He mentioned the lawsuit. It has no relevance here, but just so that the record's clean, the reason we filed a lawsuit is because Mr. Cody, who's in the room today, is a member of an entity in which we have an easement on his property, and the easement specifically says, under paragraph 1, grantor agrees that it shall cooperate with grantee in obtaining any permits, variances, licenses, permissions, governmental approvals, or other authorizations necessary for construction and operation of the sign. Okay? Well, my client paid good and valuable consideration for the easement. Mr. Cody and his predecessors, of course, agreed legally that they would not only not try to stop us, which now is what they're doing, but they would cooperate with us. Sending Mr. Hickman here to try to stop us is, of course, the opposite of cooperating with us, which, again, not relevant to this application, but so that the record's clean. That is why we had to take private action. I'm not sure what he was referring to with the 1889 deed, et cetera. It was established as right-of-way. It has always been right-of-way. Doesn't matter if it's fee or easement. ODOT owns property and fee, that is right-of-way. I-35 is right-of-way. We've established that inception, the railway was and is right-of-way. So that argument is nothing more than a red herring, and we have solved that problem. So we would ask you to deny their appeal. Thank you.
I just want to say in the record real quickly that Mr. Box's characterization of my client with regard to the easement and Mr. Cody is not accurate. I was going to leave it at that.
Okay, I've got a question. Mr. Hickman, on the visual that you provided, can you please recap? I cannot see the text here that shows each one of these boundaries.
Rita, you want one? Yeah, you're going to get one.
So if you, oh yeah, sorry. So I'll start at above the word HP District. To the left, you'll see turn to the side. It says boundary of the Heritage Hills East Urban Conservation District as per ordinance 17225. That's the green line. Below that line, but above the words HB District, is the blue line, which is identified as the limits of the HB District as per the City of Oklahoma City's zoning map. And then underneath the words HB District, and these are all words put on here by the surveyor who certified this, this document. It says, Winans 3rd Edition lies within the boundaries of the Heritage Hills East Urban Conservation District as per ordinance 17225, June 15th, 1983, and lies within the HP Historical Preservation District, property platted as Winans Park, bounded by Broadway Avenue, Northwest 20th Street, and Northwest 22nd Street, as per ordinance number 21204, January 28th, 1999, and that is the black dashed line below the blue line that I mentioned to you previously as the HP district per the City of Oklahoma City's map. And the black line is different slightly from the blue line because it identifies it by the ordinance as well as by the Winans Park addition, which I showed you that platted map. Back in the day, it was squared off and was 200 feet across in a rectangular square. And that was also shown to you by the deed that we provided, and that's what the bottom one here says, and warranty deed to the City of Oklahoma City, Book 107, page 395. Does that answer your question, sir?
Yes. So is it your position that the green line, the one that's marked boundary of the Heritage Hills East Urban Conservation District, is to be considered in the language that governs the spacing from the HP district?
Well, I mean, in fairness, I think that does apply, but I would say the one that is more directly applicable, using the words of platted or property that are in the ordinance, would be the black hash line that corresponds to the platted Winans property, which is within the boundaries of ordinance 21204, which we were provided as the applicable historic preservation ordinance for the Heritage Hills Preservation District by the city, which I provided to you, the open records request, which they
Yeah,
provided us that
I
ordinance.
get that piece. I just, simply put, can you tell me what the significance is of the Heritage Hills East Urban Conservation District boundary?
It's just another evidence of a portion of the city's districts that have been identified has requested protection from historic preservation, which that's part of what we discussed last time. And so the new information I'm providing to you that we think is more directly applicable is the information regarding the black hash line, which shows the platted property, which tracks to the language. And I believe was the discussion last time was wondering whether or not there was property, zoned property, platted property outside of the area of the curb. And we believe that this shows unequivocally that there is. And so the boundary is not the curb per the language in the signed ordinance, which refers to from the HP property. Because both the blue curve as well as the black dotted line show where the platted property is and where the boundaries are for the HP district. And that's the HP district of by ordinance 21204 as provided to us by the city. That's the boundaries.
Did the ordinance number 17225 modify the map, or I guess the description that appears in book 5066, page 85, where it shows basically, page 90 shows this map right here, and it talks about the center line of the road along basically the east part. So,
Correct. That is the one that's shown on here is the green marked line.
okay.
And that's why it runs down the center line. It preceded the more limited and specific one, which is 21204, which was passed in 1999, which is the blue curve. And I believe Ms. Friddle, when we were here last time, mentioned that there was a more specific ordinance, and we have obtained that from the city and have now put that on our map to show you that even the more specific ordinance is within 300 feet of the sign. And overlaying with that more specific ordinance that there is platted property underneath it, because the word property is what's used in the signed ordinance. So I guess to answer your question more specifically, sir, the green line is probably not applicable in light of how I would say that the ordinance is written using the word property.
That's what
And-
my concern was, is I'm trying to.
So I wasn't trying to create any confusion, I was just
Yeah.
trying to lay it all out.
Yeah, and I'll tell you why, because as we go back, I think that the code, the language that we've been referring to for purposes of applying development regulations of an individual zoning district, all such requirements should be calculated from the appropriate right-of-way line delineating a street or alley. To kind of pare this down, if your argument is that this green boundary includes that, I mean, to David's question earlier, there's still a curb on the east side of Broadway Avenue. However, I'm not sure that this boundary is applicable, so that removes that completely outside of the conversation. So for me personally, the only thing that I'm really left with, I guess struggling to understand is when we talk about the applicability of this language to a zoning district versus the HP district. And I don't know if anybody from city staff wants to talk about how you guys make that separation, that would be extremely helpful for me.
Hello, Lisa Cronister, Assistant Planning Director. Could you repeat your question, please?
Yes, so the language that we've been using about delineating, about the appropriate right-of-way delineating a street or alley, whether that is applicable to the zoning district, like in terms of base zoning, I-2, the actual uses that are allowed and types of buildings, versus being able to apply that language to an HP district. Is it?
For the purposes of the sign code and other interpretations we use center line of the pole to the edge of the property line. So not the edge of the zoning district, the edge of the individual property line.
I understand that. I just want to know if this language was intended to be applied strictly to zoning districts, I-2, O2. or-
Which language?
The language that states, for the purposes of applying the development regulations of an individual zoning district, all such requirements shall be calculated from the appropriate right-of-way line delineating a
Are
street
you,
or alley.
I'm sorry, are you reading from the sign code? Or from another part of the zoning code?
Well, it's in section 59, and that's essentially the question I'm asking. Is this language meant to be applied to the sign code specifically?
Would you tell her the rest of the section 59
Section 59-16119.
Okay. Thank you.
So this is meant to be applied directly to the sign code.
But in chapter 59, so I think it's zoning
Right.
also.
So chapter 59 is the zoning code. The new sign code is Article 16. That's new this year. I think what you were reading from is Article 5, which applies to all zoning districts. And that's Lisa's question is, are you asking her to interpret Article 5 or the new Article 16, which is the sign code?
5. I want to know if you guys apply 5 directly to signs. If
For sign code purposes, we interpret what chapter 16 says.
So then with this section, this 59-16119 be applicable just for zoning districts then? I'm sorry, if I'm trying to make it clear.
I'm here to describe how we interpreted the sign code, the new sign code, and the evaluation of this application. If there are larger questions about how other parts of the code are used for interpretation of the sign code or other applications, I can't speak to that.
But I think my understanding would be that HP is a zoning in itself.
HP is a zoning district.
Right, just like I-2 or anything else. And so the sign code reverts back to the zoning code on how to make this measurement.
I'm sorry, say that again.
I said the sign code reverts back to how to make this measurement according to the zoning code, right? I mean, that's how you interpreted how you got the measurement from that definition.
The new sign code says specifically how billboard spacing and measurement is to be measured. It says the center line, and it says the property. And those were the sections we used to evaluate this application. I'm not trying to be evasive, I'm just saying,
No.
when we wrote the new sign code, we tried to be specific and clear about what was being measured from what and where.
So it was the intention of the sign code, the new sign code, to, in a comprehensive sense, outline all of the spacing requirements for
For
signage.
signs.
For
yes.
signage.
Yes.
Without the need to supplement with any other
Yes.
portions of the code.
Yes.
Okay.
Thank you.
So then on that point, the determination of the property line, where is it?
It's the legal property line. It's usually inboard of the curb. It's what you see on county assessor, it's what you see on
So it's inside
property
the right of way.
maps. It's not the right of way,
Inside the right.
inside the right of way, property line.
But isn't on the county assessor, it may show the edge of the property, but the property may actually extend to the middle of the road.
When we interpret property line, we're not talking about to the center line of the road. We staff. We're
But it's
talking-
still property. I mean,
I
I own to the
understand.
center of my road in my neighborhood.
I understand that. I understand that's legally true. I'm saying for the purposes of staff interpretation, we take it to outside the right-of-way, up to the line of the right-of-way. That's how we interpret. But I understand that legally, technically,
Word to matter.
yes, but I'm saying how we interpret it, how we've always interpreted it.
The warranty deed came after the general grant from the United States government granting a right-of-way. The warranty deed itself had conveyance of fee language in it, did it not?
I'm sorry,
Did the deed itself contain conveyance language of fee simple title in the lands?
yes, it did.
Okay.
The city owns that land, and the land has been platted as property, and the city's own ordinance 21204, the black hatched line, actually establishing the Historic Preservation District refers to it as the the property platted as Winans Park, bounded by Broadway, 20th and 22nd. The area that you see within that black hatched area, that was the property. It is the property that was deeded and platted, and is still owned by the city. And like I said, the city could go out there and fill in the roadbed and build something.
Wait a minute, were you asking about the
I
property?
was asking about the railway
Yeah, I
first.
think he's talking about the railway.
Oh, I'm sorry.
No, you're completely fine. I'm talking about the railway. We had, yes, some grants as to railways, but the property rights, as far as a right-of-way or an easement, can be superseded. Like if I grant you an easement and later convey to you fee simple title, you now can own fee simple title, not a right-of-way.
Yes, we agree. And the document that we have submitted, the deed, does supersede the general grant from the U.S. government, the
Okay.
right-of-ways, and contains broader language than just right-of-ways.
Can I address that? I don't understand the hang-up on, a fee simple owned property can also be right-of-way. ODOT owns most of their roadway in fee simple. It's right-of-way, regardless of whether it's an easement or fee simple. ODOT
I
owns,
disagree with you, Mr. Box.
you can look all over the state. ODOT owns I-35, Broadway Extension, and fee simple title.
I'm looking at this particular property.
Okay.
And if the railway was granted fee simple title, they own fee simple title.
Which is also a
Unless there was
right-of-way.
reversionary language in there, which
But because it's fee simple doesn't mean it's also not right-of-way.
it's either or.
No, it's not. Legally, it's just not. ODOT owns 235 in fee simple title. It's also highway right-of-way.
Okay, I disagree.
So we agree with you. We think that the difference, the part they understand is because they own the fee, they could sell it and do something with it. I mean, as a fee owner, you can grant, easements and other things on your property. But it is distinguishing in that unlike a highway that's built, this is actually property, a strip of land that sits next to the site of this location, next to other ongoing businesses. And the railroad could, with their legal rights of their ownership, do something with that property and sell it, develop it, whatever. And we think that is the key distinction.
A right-of-way to me is when I take title, temporary title for a specific use, and the railroad's got it for a railway. When it was superseded with a deed and a grant of fee simple title, the nature of my ownership or the railway's ownership at that time changed.
Can we see the deed? He mentioned it. I don't know that it's actually in the record. Can we actually like,
We did submit it, Cynthia.
because what I'm trying to understand is then when ODOT acquires property and condemns property in fee for right-of-way purposes, how is that not right-of-way? Yeah, the original acquisition through Congress was right-of-way. I don't know how a
understand.
deed can supersede that.
I understand.
I mean, that's, I mean, I saw nothing in the deed that something about this deed strips away the original grant in 1884 declaring it right-of-way.
It supersedes it.
Where?
If I give you an easement as to Lot 1, and then grant you fee simple as to Lot 1, you now own fee simple, not an easement. And that's what I'm trying to say.
I can take fee simple title as right-of-way. That's how ODOT, railways, all of them own fee simple title that are also right-of-way.
That may be the purpose of what you're going to use it, but that's not what you would take title as. You would own fee simple. You can turn around and sell it. A right-of-way grants me a right to use your land for a specific purpose. And if I go outside that bounds, I lose the right to use that right-of-way.
Easement grants you things for specific purposes.
Easement and right-of-way, I've seen the language interchangeable.
They're not interchangeable. They are absolutely different terms. Legally, they are different terms. Fee simple title can be right-of-way. An easement can be right-of-way, but it can't be fee simple title. You don't own all the bundles if you have an easement. You own the entire bundle if you have fee simple.
And I think that's what the issue is, because typically when you see this, those bundle of rights are split whenever the fee simple title owner is one party and there's a right of way for another party. So in that context, yes, both can exist where you have property, there's a portion of the property that's considered right of way, but the greater overall property is owned fee simple by maybe me as a private individual. But a municipality, a state may own a right of way through that. I think Roberto's point is that if a deed was granted, and I'm trying to wrap my head around this, so don't let me speak for you. If a deed is granted a deed is granted subsequent to a right-of-way, I no longer have the right-of-way, I essentially own the property.
Initially, I gave you one bundle of stakes, and then I'm giving you it all.
And if I could address that, that is correct if it's coming from the same property owner. But if you watch chain of title here, it came from the U.S. government to a railroad company. I still haven't seen the deed, but the deed he showed briefly was a railroad company to another railroad company, meaning that railroad company that got a right-of-way can only grant the bundle of rights that they have. Their general warranty deed, whatever it says, cannot supersede anything of their original grant. I understand what you're saying, is if the government were to issue right-of-way and then later on the government issued a warranty deed, but that's not what happened. It was acquired as right-of-way. A rail company that acquired it as right-of-way later deeded it. They can only deed the rights of which they acquired. So there is no superseding. That's not possible. That would violate every property principle I've ever been taught.
You're presuming that the U.S. who instituted this big act back in the mid-1800s, you're saying that they had the right there, but then when that deed was filed in 1899, or whatever the specific date was, you're saying that that grantor did not have the rights to grant that deed?
The grantor can only grant the rights in which they own. It's the nature of the beast. If what they own was acquired as right-of-way through the initial government act, they can then grant whatever rights that they own.
So
If it was right-of-way, they can only grant right-of-way. If it was fee simple, they could grant fee simple, but it was acquired as right-of-way. Next person in line, it's chain of
But
title.
the
It's not-
right, but the grantee in both instances is going to be the railway. There
it's
was
gonna be
no
railway-
grant, there
Railway
was no
right-of-way
grant,
as
in
it
the-
was originally acquired, yes.
there was no grant from the railway in 1899, is that correct?
It's my understanding, again, I still haven't seen the deed, I don't think it was submitted, it was never provided to us. The deed that he briefly showed was from a railway company to a railway company. The original railway company acquired it from the federal government. They can then only go in turn and sell or convey the rights in which they own, which of course was the original
So
grant.
is your position then is that the government actually still owns the land, they only conveyed the right-of-way, in which would limit what ownership could then be transferred to another railway company?
There it is limited based on the original conveyance as railway right-of-way.
One other thing, we spent a lot of effort on this. It's also worth noting that it is one contiguous piece of property that is zoned I-2. The contiguous piece of property abuts Broadway Avenue. Broadway Avenue is a major arterial. Under the sign code, major arterials zoned I-2 are permitted billboards. Doesn't matter that it shows track 2 on that because that's the easement track that we own. It's a one contiguous piece of property with frontage on Broadway, which under the sign code gets us a billboard.
The easement inside the property.
I just want to make it clear for the record that they haven't shown you any evidence that this property where the sign's being constructed bounds with Broadway. And if they were saying that it does bound with Broadway, then there's a whole nother set of issues because there are spacing requirements between billboard signs, and my client has an ownership interest in a sign on Broadway that would potentially impede the spacing of the location of this sign. So this is a new argument, a new twist, but it also raises other problems that were not addressed in the permitting process because it was not portrayed in the permitting process as this sign being read to Broadway. And therefore, I think this is just confusing the record and it's not applicable.
So perhaps we look at, this is, I think, Lamar's exhibit. Yeah, this is Lamar's exhibit. The blue is the subject property. The blue abuts Broadway because the green, you can see tracks, I think it's part of the center line and part of that urban conservation, but blue is subject tract. Subject tract directly abuts Broadway Avenue. So again, it's one contiguous piece of property. That property is zoned I-2. That property abuts Broadway Avenue. That property abutting Broadway Avenue, zoned I-2, under the sign code, explicitly allowed non-accessory signage.
If you look at, can you put up Natives exhibit? Lamar's exhibit doesn't show their easement, their actual legal property rights that they have. Rather, their sign, their survey does. And it's one of the slides in my presentation. Yes. It's in my packet though. Yeah, it's that one. There we go. If you actually look at their own survey, it shows Lot 2 over on the right, and then you see the configuration of the sign structure. That identifies the sign easement area, the rights that they have to build the location of their sign. They do not have rights across the entire tract of the property to put the sign wherever they want that would be bounding to Broadway.
Well, does the code speak to the rights they have, or does it just speak to the property? Because
Property.
But to be clear, they're not the property owner, don't have property rights.
We do have property rights. We own an easement that has property rights.
And the easement is bounded by Lot 2, that's it.
But correct me if I'm wrong, I don't think the code limits the property to the easement. I think the code is concerned with whether the property would abut Broadway in this case, which it looks like it does.
Correct.
Well, they have no rights to build the sign in the areas that would abut Broadway, if it actually even does. That is an alleyway there that is privately owned, and you can see where the southern part of it is right on the driveway into the parking lot.
Well, we know it
So-
does because we know we can't have landlocked parcels here. And so we know that the parent tract absolutely abuts Broadway.
The property is not landlocked. There was a roadway right there. You can see in between the two of them. That was an alley, and it was subsequently foreclosed as an alley and is now a private drive that provides access to the properties. It's not landlocked. There was an alleyway there that's now a private roadway.
It abuts Broadway, period.
I don't know that this matters. I'll tell you guys, for me, I've really struggled with trying to determine the language that talks about property. That's where I've really been focused on. I think that Mr. Box is correct when it comes to, I think that they can meet the requirements given that the property does abut Broadway, but I don't think that that solves the issue when it comes to HP. I think that the property that's identified as being under HP, and based on, I think it was Katie that made a statement at the last meeting that the way that they don't limit the language of HP to just structures, property is property. I can't see how we don't get outside of identifying the HP district as being property, HP district as outlined by the boundary as being property that is then within that 300-foot radius from the pole. I'm interested to hear what you guys have to say, but that's the only issue here for me.
So for me personally, I'm in agreement with the 300. I don't think the 300 feet is met. And I still disagree as to the nature of the ownership rights by the railway. So, I mean, I'm in favor of granting the appeal. I'm not sure there's anything that we can decide today. I'm not sure if we can get 3 votes based off of who's here and the way we voted last time, so. And I believe that if we cannot come to a consensus, that we will be back here again.
Roll it over to the next meeting.
All right.
So, thank you.
Make a motion?
Yes, unless anybody wants to be heard. Anyone else?
Okay, I'll make a motion to approve or grant the appeal in case number 15736.
Second.
There's been a motion and a second to grant the appeal.
Can we show it just so that there's,
It didn't pass. It was 2-1.
It's 2-1, so. So there need to be 3 votes. There need to be 3
to
votes.
the vote was 2-1, so it is not.
Since we're having difficulty, should we do voice vote? Yeah.
Voice vote would be appropriate.
Voice vote.
Okay. Mr. Udi, how do you vote?
Yes.
Mr. Ursita?
Yes.
Mr. Noble?
Nay.
Correct. We're at the end of our docket. Item number 3 was deferred. So now we're down to additional items.
David Yelby.
Adopting the Board of Adjustment meeting calendar for year 2025.
I have to make a motion for that?
Any discussion on that? But yeah.
We do have to make a
Did you
motion?
see the months that we took out a date?
It's the last page of the packet.
My packet's all messed up now. I flipped too many pages. Yup.
So June has one meeting, July has one meeting, December has one meeting, November has one meeting. I mean, who doesn't like that?
I'm in favor of that. So motion to approve the 2025 Board of Adjustment proposed calendar.
Second.
We have a motion and a second. We can do the math. I think we broke it. Well, it came and went. It passed. Is that it? Communications and reports? None? Citizens to be heard? They've all left. With that, an adjournment?
I may have had something to say. I've never had anything to say.
I just want to remind y'all of our special meeting on the 21st. We're all still good?